because of the reckless choices that the defendant made that murdered Vanessa Sullivan. Today, the facts have shown beyond a reasonable doubt that the defendant acted with reckless disregard for human life. This is a story of three friends who simply went to a bar to celebrate a momentous occasion. It was the responsibility of the defendant to get her friends home safely. It was her responsibility to abstain from alcohol. However, the defendant was irresponsible. She chose to drink. She chose to drive. She chose for Vanessa Sullivan to die. And that is why you are here today. Today, the defendant was on trial for two crimes: DUI and murder. Allow me to explain these charges in more depth. With respect to the DUI, we heard from Taylor Hobson, testifying that she saw the defendant get into the car while appearing intoxicated. However, the law states that you cannot merely be convicted on mere speculation. That is why you heard from Officer Foster, who testified that the defendant was in fact under the influence of alcohol while behind the wheel. She concluded this through her own field sobriety test that she conducted after the accident. On the count of murder, the prosecution had the burden of proof. It wasn't enough that the defendant was drunk while behind the wheel, but that she made choices that proved she was both extremely reckless and disregarded human life. This is the burden of proof that we have met today. We've heard a lot of facts that were given by many people. Remember Officer Foster, who testified that the defendant was speeding at 66 miles per hour on Canyon Road. Remember Sam Lyons, who offered 3 times to give the defendant a safe ride home. Remember Taylor Hobson, who pleaded, no, begged the defendant to just slow down. Instead was ignored by a reckless and intoxicated driver. It was not just the drinks that the defendant had at the bar that night that killed Vanessa Sullivan. It was the defendant's choices that makes this murder. Now, while there was no gun or knife in this case, the weapon here is the defendant's choices. She chose to drink, despite knowing she would later have to drive. And every drink was like loading bullets into the chamber of a gun. The defendant chose to drive, which is as if she pulled back the hammer of the gun. Finally, the defendant chose to speed and swerve on a road that she knew was dangerous. A road she knew that had claimed lives in the past. And this, ladies and gentlemen, is as if she put the gun to Vanessa Sullivan's head and pulled the trigger. Make no mistake, the defendant and the choices she made murdered Vanessa Sullivan. Ensure that justice is done, and see that the defendant is held responsible for her choices. When you come back from deliberation, find the defendant guilty of driving under the influence of alcohol and the murder of Vanessa Sullivan. Defense rest, Your Honor.
Defense prepared for their closing arguments?
Yes, Your Honor.
Yes, that's the prosecution.
May it please the court? At the beginning of today's trial, we told you that this was an accident that could have happened to anyone. Members of the jury, after the facts of today's case, this still remains true. We heard the Canyon Road was a dangerous road. The lanes are narrow and the curves are steep. People have died here before. Ms. Danielle Dawson was navigating this road in the dark, in the rain, and with a lot of distractions all around her. When an animal darted in front of her car, that is when she swerved. This could have happened to anyone. Now today, the prosecution has told you repeatedly that Danielle Dawson is a murderer. They have the burden of proving each and every accusation beyond a reasonable doubt. Danielle Dawson does not have to prove anything. We know that she was drinking that night, and we know that she drove the car. But these mistakes are not what caused that accident. The prosecution has not proved that Danielle Dawson was reckless, extremely reckless and indifferent to human life. That what she did was equivalent to cold-blooded murder. They have centered their case around two facts: how much Ms. Dawson drank and how fast she drove. I want to walk you through these two facts. I would like to start off with how much Ms. Dawson drank. You heard Sam Lyons say that he only saw Ms. Dawson have 2 drinks over a 7-hour time span. You also heard Officer Foster give her testimony, about Ms. Dawson having failed 1 preliminary test and 3 field sobriety tests. He even went as far as to say that Ms. Dawson was so drunk that she couldn't even walk heel to toe in a straight line without slipping. But on cross-examination, you heard her admit to almost having slipped too. Now, how could she conduct a test that she couldn't even pass herself? But that's not all. We also heard that Mrs. Sullivan, the victim's mother, was on the scene, screaming at my client while she was trying to perform these tests. Who wouldn't tremble in a situation like this? Who wouldn't stumble? We also heard from Taylor Hobson, the victim's best friend. She planned to get drunk that night. She also does not know her limits. She claimed that Danielle Dawson was speeding, driving recklessly, and that there was no deer. Yet, Ms. Hobson was in the back seat of that car. She also admitted to it being hard to see, considering the fact that it was dark and pouring down rain. Those facts alone, we ask you to find the defense innocent. But there's a second separate reason why we ask you to find in the defense. The prosecution has failed to prove that Danielle Dawson was driving recklessly. We heard Officer Foster say she clocked the car going 54 miles per hour, yet she didn't pull her over. So on one hand, the prosecution wants you to believe that she was driving so recklessly that it constitutes murder. But on the other hand, she wasn't driving recklessly enough to deserve a speeding ticket. That does not add up. The prosecution has also failed to prove